Welcome to Case Flash, brought to you by the CBA Family Law Section. I'm Sam Schoonmaker, and with me today are Judge Elaine Gordon and Attorney Alan Palmer. Today's Case Flash addresses when a party's voluntary actions can give rise to a substantial change of circumstances in the Supreme Court's decision in Olson v. Mohammadu. First, the basic facts. The parties divorced in 2009, and at that time, the plaintiff mother and the child lived in Connecticut, and the father resided in Florida. Several months later, the father found a new job, relocated to Connecticut, and filed a motion to modify based on a reduction in his income. The father testified at the hearing that he relocated to be closer to his child. The trial court found no substantial change in circumstances, and it denied the motion. The trial court based its decision on the voluntary nature of the alleged substantial change. The decision to relocate may have been a good parenting decision, but the father had a child support obligation that he had to meet. The appellate court affirmed, reasoning that the trial court did not need to consider the father's motivation for moving in connection with determining whether there had been a substantial change. The trial court reasonably could have concluded that the defendant's unilateral action was an unacceptable reason for a reduction in his income. His motivation only would be relevant in Step 2 of the Borkowski analysis after the trial court had already found a substantial change. The Supreme Court granted certification, and then it reversed. Attorney Palmer, what did the Supreme Court decide here?
The thrust of the Supreme Court's opinion was to clarify the use of the term fault in the Sancioni decision from 1977. Historically, since the case of Gleason in 1988, we've always applied the word fault as meaning voluntary. What the Supreme Court does in Olson versus Mohammadu is it equates the term fault with culpability and no longer equates it with the term voluntary.
Judge Gordon, what is culpable conduct, and how do you determine that?
Well, culpable conduct most generally defined is conduct which is blameworthy. If you look in the dictionary, you can find that it's deserving of censure, it's wrong, it's evil, it's improper, it's injurious, it's anything kind of bad short of criminal. So it's bad conduct that's not criminal, is culpable conduct. So it's a pretty broad definition, it seems to me.
Sounds like there's a lot of gray in that definition. Attorney Palmer, is there a bright line test that we have now?
Well, one of the interesting things about the opinion is I think it blurs what had been a bright line test. The way Sancioni was interpreted by the appellate court and the Supreme Court previously, it really equated the term fault with voluntary actions. That's really clear in terms of creating a bright line. If it was voluntary, then the person wasn't entitled to modification and wasn't entitled to a defense of inability to pay. What's happened now is that the trial court is required to look beyond the voluntariness of the action and determine whether there's a reasonable excuse for the action taken by the person taking the action.
What do you think the burden of proof is on that inquiry?
Well, I think that the court basically says that it's up to the person moving for the modification to show that they did this for a purpose that's not culpable. They talk about that they have the burden of showing that it is not due to their own extravagance, neglect, or misconduct, citing Sancioni, and also that it causes, it would be unjust given all of the circumstances. So I think the person moving has the burden to show two things. One, that there's been a financial change in the circumstances that's substantial, and two, that it's not due to culpable conduct.
And in the last sentence of footnote 6, the Supreme Court writes, a party whose culpable conduct forms the sole basis of an alleged substantial change in circumstances will likely be unable to demonstrate that it would be unjust or inequitable to maintain the existing alimony or child support orders. I think the use of the word will likely be unable to demonstrate underscores that the burden remains with the moving party.
Would you say, though, that there's going to be a fair amount of litigation determining the contours of what is now culpability?
Oh, I think there's going to be a lot of litigation because before advice was like pretty simple that you would tell a client, I think, you're at risk, it's voluntary, and now there's going to be a lot more, I think, discussion about what's actually going on, what's the motivation, what are the real reasons behind the decisions that you're making. And I think this case is interesting in that it appears, I've said this before in our discussions, it appears very simplistic on one level. That is, how can you say that somebody moving to Connecticut to be closer to their child is not worthy of a modification? Isn't that a good reason? But if you read through all the footnotes in the hearing that actually took place, it was a little bit more complicated than that. So I think that we're going to see complicated cases and complicated facts and more evidentiary hearings.
And the burden, I think, is elevated to some extent because what has to be proven by the moving party is that the conduct was without fault. And having to prove a negative is always much more difficult than having to prove a positive act. So the proof necessary is to prove that your action is without fault, without culpable conduct, as opposed to shifting the burden to the other side to say this is bad and this is why it is culpable.
Well, isn't it almost like you have to prove that you had a good purpose? Kind of like this person say, I did this to be close to my child?
Are you saying you think it might be more difficult to prove a substantial change of circumstances?
No, I think it's going to be easier to change.
I think it is. But there's still going to be judicial discretion in sorting out a good motion to modify and a bad motion to modify based on the facts.
Yes, and I think that the Supreme Court, I think the complexity of the undertaking was argued on behalf of the appellee to the court, and the court said that they thought that the lower courts were perfectly capable of doing having the hearing and sorting it all out. I think, though, that what's interesting about this case is that one worries, I think this is a cautionary tale to judges about how opinions may have to be written in order to be clear to appellate courts reading them. Because, for instance, I don't think anybody's ever thought of motions for modification on busy short calendar as the two-step Borkowski inquiry. I mean, people just basically say, they look at financial affidavits and say, is there a substantial change of circumstances? Have the dollars gone down? Does it look roughly like it's been? And then they wait for somebody to tell them that something bad happened, like, they quit, as opposed to having been fired for no misconduct, and then figure it out. So I think courts have been generally doing it correctly. And in this case, if you read the decision and the footnotes, it seems to me that all the inquiry actually did occur during the hearing. The appellant testified about why he moved, and the court made findings, albeit in a footnote, maybe not findings, maybe an afterthought, about whether or not there was a financial change in circumstance. But it wasn't presented in a way where it appeared to have been the inquiry that the Supreme Court was looking for. It sounded like it was all based on just a voluntary decision.
And then that footnote saying that it was actually within the deviation, the 15% deviation was
Right.
more like an afterthought, but
Right.
not the reason for the decision.
Right, because they did argue that it didn't need to be remanded because that decision had already been made, that there hadn't been a financial change in circumstance.
Attorney Palmer, have there been cases where the two-step Borkowski case gets bifurcated? And what does this decision do for bifurcation of that?
At the appellate level, I don't know of any family cases directly dealing with this on point. However, in practice, I've seen an increase in motions for bifurcation in post-judgment modification proceedings, both on the parenting side as well as the financial side. I think what Olson versus Mohammadu does is it should put an end to that. The Supreme Court specifically says that it's a very low threshold to get from the first prong of Borkowski to the second prong. Once one of the parties puts on any evidence showing a decrease in income, then we get to step 2 of the Borkowski analysis, and I think that does away with the necessity for a bifurcated hearing.
What do you think of the practical effects of this decision beyond what you've already said?
Busier short calendars, I think that's the practical effect. I think that's been the practical effect of Many of the appellate decisions, I mean, this was a decision that basically said you have to have to the trial courts, it said you have to have a more detailed hearing. This is a more complex matter than just voluntary, not voluntary. This is about blameworthy behavior or not blameworthy behavior. And you have to have that evidentiary hearing and determine that. You can't just have a bright line.
Well, while the Supreme Court is very deferential to the trial courts in this case, they do consider an increase in claims where finances may be affected by parenting decisions, in footnote 12 specifically, and it dispenses with that argument in relatively short order. First of all, it's simply footnoted. It's not part of the body of the decision. But in the footnote, it says the mere possibility that a party may fabricate testimony regarding the ostensibly acceptable reasons for the voluntary conduct resulting in an alleged inability to pay does not require that we abandon the settled methods for distinguishing between credible and incredible testimony. So clearly the Supreme Court is saying, look, we have this discretionary trial court system, that acts based on discretion, and we're going to let the trial courts continue to exercise that discretion. We're going to allow the trial courts to continue to assess credibility, and the trial courts will weed these cases out.
Right, in longer evidentiary hearings
Right.
at short calendar. So, and maybe it's a resources problem. I think family law has gotten for the courts and for the litigants and the lawyers much more complex than it was even just 10 years ago. And maybe more research, the judicial branch needs to put more resources, that is, more people onto that docket in order to take care of some of the complexity that's been created.
Olson v. Mohammadu is a very significant case, especially for the routine day-to-day practice of family law. Thank you for watching Case Flash.